Good evening. Thank you to everyone for attending this James Wilson Institute event tonight. My name is Bill Richterman. It's my pleasure to welcome you. After nearly 20 years in the Bush White House and in the Senate and the House, I'm a member of the Public Policy Practice Group here at Covington, of which I'm very proud. In fact, many of you know some of our esteemed colleagues. The chair of our practice group back there, John Verno, who's Deputy USDR and Bush 43, also Senator John Kyle, who's been the Republican whip in the Senate. First, a few logistics. Please join me in muting your phones. After the panel discussion, there will be a time for Q&A, and once completed, hope you'll join us for drinks and hors d'oeuvres in the foyer. A word about the James Wilson Institute. The JWI was founded by my friend Hadley Artis in 2013. Their mission is to restore among lawyers, judges, scholars, and citizens the understanding of the American founders about the first principles of our law and the moral grounds of their rights, what we call natural rights. JWI advances its mission through hosting private seminars, public forums like this, lectures, and by publishing essays on key issues found in American jurisprudence today. If you're interested in learning more about the Institute or staying updated with their writings and events, check out the information on your chairs or the table in the foyer, or their website, of course. It's now my high honor to introduce my friend and mentor, Dr. Hadley Artis, the founder and director of the James Wilson Institute. Hadley Artis has been a member of the Amherst College faculty since 1966. Are you still, though?
Last run.
Last one. And since 1987, he's been the Edward Ney Professor of Jurisprudence. He's written 5 books with Princeton University Press, including Bureaucracy and the Marshall Plan and the National Interest, The Philosopher in the City, First Things, Beyond the Constitution, and The Return of George Sutherland. But his most recent books have been with Cambridge University Press, including Natural Rights and the Right to Choose, and Constitutional Illusions and Anchoring Truths, the Touchstone of the Natural Law. He's become known to a wider audience through his writings in the Wall Street Journal, the Weekly Standard, and National Review. He's been a contributor also to First Things, a journal that took its name from his book of that same title. For 8 years, he wrote a column for Crisis Magazine under the title Life Watch, and he's carried over that concern as one of the band of friends who formed a new web journal called The Catholic Thing. He was the main advocate and architect of the bill that became known as the Born Alive Infants Protection Act, which became the law of the land President Bush's first term. Hadley is as spry as a spring chicken. And in many years I've known him, he seems to have suspended the aging process. Intellectually, he's as sharp as they come. And he's an excellent writer, thinker, and debater. And he's a visionary and a doer, a rare combination among academics. And I'm so proud to call him my friend. Please join me in welcoming Dr. Hadley Artis.
That was a thicker introduction than I was expecting. It reminds me of the old cartoon in the New Yorker, 19th century figure, and by the base of the statue, the persons are like apps. He's pointing out here, and on the pencil it says, statesman, author, patriot, but still a disappointment to his mother. Well, that was a thick introduction, and first I want to thank Bill and our friends at Covington and Berlin for making this available to friends of the James Wilson Institute, old and new. He used to have a portrait of Dean Acheson in this place, and I was thinking of him today that I'd only listen to his old line. Don't just do something, stand there. I wouldn't come here with this bandage on my head, but all I told her was, I don't see why he has to accept the outcome of the election. I'd like to slip in a word of thanks to my deft and devoted aides, Garrett Stemick over here and Margaret Kalaki, for working with Bill arranging this space for us. And with a bit of shameless commerce, I would point out Mike Maybach over here, my old friend and former Director of Public Relations for Intel, who's joined the James Wilson Institute now as Director of Operations. And if people here are interested in hearing more about the Institute, and how to support it. Michael make house calls. but see him and Garrett at the end of the program. Maybe I haven't come in to say a few things as we finish. We're going to follow today kind of the old Rukeyser format, Wall Street Week. But I thought I'd say a few words to frame the conversation, and then I may join me with my friends to continue the conversation. And so, ladies and gentlemen, the line came, I think, from George Terrell, the Irish Jesuit, so-called modernist theologian at the end of that last century. And he said, if the Jesuits were accused of killing 3 men and a dog, they'd invariably produce the dog alive. Well, Tim Kaine must have absorbed those kinds of lessons in the time he spent with the Jesuits. Or how else to account the answer he gave when he was asked in the debate with Mike Pence on Hillary Clinton, the Secretary of State, that she was discussing on an insecure email, sensitive, classified material labeled top secret, quite likely to have been hacked by other countries. In fact, we've had that confirmed now by the FBI report that this stuff was hacked. In other words, people abroad who put their lives on the line in order to cooperate with American forces might well have been put in lethal danger. Kaine replied to all of this simply by reporting in a cheerful way that James Comey, the director of the FBI, had offered his seasoned sense of things that no reasonable prosecutor would seek to prosecute him. What Kaine notably left out, of course, were these judgments set down by Comey. That Secretary Clinton and her colleagues were, quote, extremely careless in their handling of very sensitive, highly classified information. That she and her colleagues, as Comey said, were surely in a position to have known that an unclassified system was no place for that conversation. Well, we're not here really to pour over again the record of Hillary Clinton, because what's been set down, I think, is bad enough. And we're now only starting to see the evidence setting in place on the ways in which the FBI disfigured itself in its willingness to break from its own precedents for the sake of avoiding collecting even more material. There was that curious granting of immunity, the unaccountable failure to put Mrs. Clinton under oath to catch the kinds of discrepancies that had been sufficient to lead to the prosecution of Scooter Libby, or the decision to report Cheryl Mills the installation of the client even while she herself was a possible likely target of the investigation. Andy McCarthy has written extensively and brilliantly on all these points. And our friend Noel Francisco has written on the dramatic contrast between the kind of investigation carried out here and the one waged by the FBI and the Department of Justice in trying to bring down Governor Donald in Virginia. As I say, we're putting aside those charges against Hillary Clinton. We're here on the premise that the decision made by James Comey, put forth with such high visibility, that decision constitutes in itself a separate moral and jural problem. That problem is bound up with the meanings that attach to term precedent. We're starting to see a certain demoralization in the FBI and other parts of the government, with people having to enforce these kinds of laws on others. Sean Bigley has in hand clients faced with grave penalties for doing things far less grave than things done by Hillary. And the rule brought forth now for Mrs. Clinton will be honored in their cases as well. There seems to be these days a certain kind of inattentiveness to the rival meanings of precedent. It appears that many lawyers have simply fallen into the notion of precedent that follows the understanding of Justice Holmes, that what we mean by the law is a prediction of what judges are likely to do. In that sense of the problem, the notion of a precedent is bound up with the concern of simply giving people predictions of high probability on what they can expect. But Holmes spoke the voice of the modern project in law when he offered that hope that half the law that every word of moral significance will be purged from the law altogether, and lawmakers to wield sights this way. But of course, it's the moral sense of precedent that cannot be extinguished, especially for ordinary folk unburdened with a degree of law. They're more likely to ask the question, why aren't you willing to respect today the rules you handed down yesterday? Why are you not willing to apply to yourself the same rules you enforce on other people? The way in which the term precedent here converges with the categorical imperative of the rule. 18 years ago, when we were in the middle of an impeachment in this country, Bill Benner and I did a piece for the Wall Street Journal in which we asked simply whether the same rules had been in place for the impeachment of Richard Nixon were to be taken as ground of impeachment now for Mr. Clinton. Because Nixon was accused in a high accusation of suborning perjury. Was that charge to be respected now in the case of Clinton? Which is another way of asking whether the Democrats who controlled Congress and voted for Nixon's impeachment, were they willing to live now with the same laws they're willing to hand out earlier for others? We think we have a comparable question now in the aftermath of James Comey's decision on Hillary Clinton. That question is given an added edge of danger by the real connections to matters of national security. Yes, we've heard that the system of classification has been widely abused and so many things are overclassified. But none of that displaces the hard fact that there is material that must be kept under the veil of secrecy precisely because it is necessary, even for the best regimes, to have a national defense, to carry out military operations, and along with those operations comes matters of intelligence and spying, and pieces of information that simply may not, ought not be shared with adversaries. So the truly serious problem faced now by James Comey's decision would be, on what ground would it be possible any longer to sustain any serious program of classified information and keep strategic information out of the hands of real enemies if Hillary Clinton could be given the kind of pass she was given as she handled the most sensitive and possibly dangerous material with a mode of conduct that could be called reckless disregard of the interests of the law was seeking to protect. That standard, as I understand, hasn't shown any imaginative apologies over intent. The seriousness of the offense was thought to be diminished. It's not thought to be diminished by the most well-meaning intentions. But the lives of people may be hinging on the fact that grown-ups with responsibilities of office will treat those responsibilities with what was called in the Declaration of Independence a decent respect. In this case, a decent respect for what is being protected in these rules. Sean Bigley, fairly early in the practice of law, found himself drawing clients, testing the seams, precisely, of this grave problem. He's the founder and managing partner, even at such a young age, of Bigley Granish. The firm is believed to be the only firm in the nation now with this exclusive focus, a niche practice of defending federal employees and contractors, case involving the denial and revoking of security clearance. The lawyers at Sean's firm regularly appear before tribunals and agencies ranging from the CIA to the Department of Justice. Their roster of clients includes spies, diplomats, members of the armed forces, other people holding security clearances. 200 clients in all right now. The proceedings are often administrative, but as Sean points out, the penalties are severe, with people threatened with the loss of career and livelihood. In the last year alone, Sean and his colleagues have represented clients in nearly every state, as well as in Iraq, Afghanistan, Germany, Korea, Japan, United Kingdom, Australia, China, and in a couple of actions aboard 2 Navy vessels at sea. Joining him will be my good friend of many years, Andy McCarthy, who's become, I think, the premier writer on the pressing issues of law in our own day. He's come to it by working in the system of criminal justice since he was a student at Columbia when he was about 19, with witness protection program. And then in law school for his practical experience as a prosecutor. I may be applied for that.
I was going to say, now I need the witness protection.
Yeah, save a place for us and figure out where we're going to live for the next few years. I'm looking into real estate in Malta. I want to mention his practical experience as a prosecutor in the U.S. Attorney's Office in New York. He led, as many of you know, several notable prosecutions, including the case against Omar Abdel Rahman and 11 other jihadists, convicted in 1995 of seditious conspiracy. I love that term, seditious conspiracy. Bring it back. Seditious libel. Seditious conspiracy to wage a war of urban terrorism against the states. That campaign of terror did include the bombing of the World Trade Center in 1993 and the subsequent plot to bomb landmarks in New York. In the aftermath of that attack on 9/11, he helped supervise the government's command post at Ground Zero. In his book, Willful Blindness, he recalled that lawyers in that command post after 9/11 exclaiming, "God, just consider the liability." Wow, the language of lawyers, and he found himself in disbelief that this is how the United States deals with the state of warfare, by pretending that it's a matter of law enforcement with the usual restraints of the criminal law. And he's been writing day in and day out for National Review and other publications. He's been writing superbly with that clarity of mind that may be cultivated among prosecutors, but also with the historical learning that reflects the serious study that he's had to undertake of Islam. And that study has been reflected in another of his 5 books, The Grand Jihad. But I know that in the study of the law, he had some tutoring at the trial for the bombing of the World Trade Center. He had that tutoring from the hand of the judge who presided with such a focus and moral rigor over that trial, and no one other than our friend Michael Casey. And he's become our preeminent writer on law, and Michael, I think, has simply become one of our preeminent public men. He, too, was a child of the city. He went to the law school, Columbia, before doing his law degree at Yale. He served from 1988 to 2006 as district judge in Southern District of New York, last year as chief judge. In his book, Willful Blindness, Andy McCarthy noted the comment of the Court of Appeals on the appeal made in the case of Black Sheik. And the court remarked that the trial judge in this case, the Honorable Michael Casey, presided with extraordinary skill and patience, assuring fairness to the prosecution and to each defendant, and helpfulness to the jury. His was an outstanding achievement in the face of challenges far beyond those normally endured by a trial judge. So the judge went on to become, as you know, Attorney General in the latter days of the administration of George W. Bush. He served with that distinct blend of savvy, that worldliness of one who grew up in the city, along with the wisdom cultivated by one who made his living in that city. He's returned to the practice of law at great Amherst College firm of Clinton and Debevoise. But as a writer, consistently engaged, he's been the source of sage commentary. I think for Michael Casey, I'm inclined to draw upon that line from All's Well That Ends Well, another line of one who was praised for his expertise in giving counsel. Wrote said, "His honor clocked to itself, knew the true minute, when a deception bade him speak. At that moment, his tongue obeyed his hand." That, I think, is Michael Casey. Now, I want to open this with our friend Sean. Sean has been quite clear on these, written with remarkable clarity on these issues. I thought he has the stories to tell. But before we launch into the stories and get commentaries, and Judge Casey told me his own angle was he thought that Hillary would be indicted. That's an interesting angle on this problem. But before we get into the stories, I thought it would be helpful. Sean, why would it be helpful if you could just give us sort of the main ingredients of what the statute is, and what your clients are facing?
Sure. Well, thank you, Hadley, for the gracious welcome, and thank you all for being here this evening. Our firm exclusively represents federal employees and contractors, as Hadley noted, who are fighting the denial or revocation of the security clearance. And these are administrative matters, they're not criminal matters, but in many cases, a criminal case will flow out of that administrative matter. The most common example being someone who has willingly and intentionally falsified their security clearance paperwork. Great example in recent news, 2 DEA agents in New York were charged and subsequently convicted with running a strip club on the side and employing women to work there who were legal aliens, using the operation to launder money, among other crimes. And they didn't report that, surprisingly, on their 96, which is their security clearance application. Now, those of you in the room who may have held a security clearance at some point would be familiar with that. It's a 127-page form that all of us who held a security clearance have the joy of filling out every 5 years. And in essence, what it is your life history. The government is interested in knowing where you've lived, who you know, where you worked, and the ultimate idea behind it is to determine whether or not there's anything about you or your background that could be used against you for blackmail, or that would potentially impact your reliability, your judgment, your honesty, any of the character traits that we would want to see in somebody who we are giving access to classified information. Now, security clearance law is governed exclusively by executive orders and regulations. It's not a statutory creature. And ironically, one of the primary executive orders that governs this area, Executive Order 12968, was signed in 1995 by President Bill Clinton. Now, the irony here is, as a result of that executive order, we have what's now referred to as the National Adjudicative Guidelines for security clearances. In essence, it's 13 categories under which someone could be deemed unfit for access to classified information. Those categories include things like foreign influence, mental health, financial problems, anything that would perhaps impact someone's, as I said, honesty, reliability, judgment. And those adjudicated guidelines apply uniformly, or at least in theory, they're to be applied uniformly across all federal agencies, including the Executive Office of the President. If you read the adjudicated guidelines, which I happen to bring with me, they leave very little room for ambiguity, especially as it pertains to the type of misconduct that Mrs. Clinton is alleged to have committed. And I'll read you a little bit of a sample here. This is the adjudicated guideline K for handling of protected information. It says, the concern, deliberate or negligent failure to comply with rules and regulations for protecting classified or other sensitive information raises doubt about an individual's trustworthiness, judgment, reliability, or willingness and ability to safeguard such information, and is a security concerns that could raise the security conditions, that could raise the security concern and may be disqualifying include, in part, negligent disclosure of classified or other protected information to unauthorized persons, collecting or storing classified information or other protected information on any unauthorized location, loading, drafting, editing, modifying, storing, etc., etc. The list goes on and on. Also relevant in this case is Guideline M, use of information technology systems. That includes all computer hardware, software, firmware, etc. And conditions that could raise a security concern and may be disqualifying include downloading, storing, or transmitting classified information on or to any unauthorized software, hardware, or information technology system. Again, not a lot of ambiguity there. So the point that I've made and the point that I've tried to communicate in my writing has been there's really two separate issues here. One is the criminal aspect, and I will defer to Judge Mukasey and Andy on that. That's a little bit outside of my area of expertise. But the other is the security aspect. And I think we'll get into this a little bit later, but there are some real questions that arise when someone has exhibited this type of behavior in the past as to whether the future conduct or prospective conduct is something that we would feel comfortable with respect to classified information. So,
I think you said at one point that this order that Bill Clinton signed is so we went down checking off every item from Hillary. She's violated every one of them.
that's exactly right. You can't make this stuff up. I mean, it's literally written as though it were, as though he knew 20 years into the future exactly what we would be dealing with now.
I want to do one more thing for me before we bring the judge and Andy. In the FBI report, which I have, he said they said they determined that there were 81 email chains which the FBI investigation determined were transmitted and stored in Clinton's unclassified personal servers. 81 of them. Then it's broken down, and they found, through the litigation, they discovered 2,000 additional emails. Now, in process to that, would you tell the story of that Navy SEAL?
Absolutely. So, when the news broke for the first time about Mrs. Clinton and her homebrew server, one of the first things that came to my mind was a case that our firm had the privilege of handling about a year ago. And I should preface this with the fact that these cases are typically done behind closed doors. There are two federal agencies, the Department of Defense and the Department of Energy, that do publish their decisions, with the names redacted, of course. Most other agencies, certainly the intelligence community, this is all done behind closed doors. The opinions never see the light of day. So it's very difficult from a precedent standpoint as an attorney to argue these cases, because really all we have is our anecdotal evidence of, we've handled, for example, X number of cases at this agency. We've seen this is how they typically handle an issue like this. But outside of that, we can't ever typically research precedent. In this situation, one of our clients about a year ago was a Navy SEAL, came to our firm. He was on the verge of being booted out of the military entirely, having his security clearance revoked. And for what great transgression, you ask, he took a cell phone picture of a classified page in a classified training manual that he had intended to use for some purpose in the scope of his duties.
Because he just wanted to remember it, huh?
Exactly. Wanted to remember it, study it, conceded in hindsight that that was a mistake, but wasn't caught until he was participating in an exercise on a military base in which there were role players, and the local authority role players happened to be the military police on the base. They stopped him and his colleagues and conducted a mock search, stumbled upon his cell phone, and lo and behold, it was a classified document. Now you can imagine that role play
one
came,
document.
One document. You can imagine that role play came to a very quick and grinding halt, and he was severely reprimanded. But the contrast here is we're talking about, as you said, Hadley, one document. And somebody who arguably has dedicated, well, not arguably, has dedicated their life to the United States, and arguably should have known better, but I don't know that anyone could objectively look at that situation and say this is something that would result in the person being discharged from the military. But that is how serious the government takes some of these cases. Many times when one mistake is made, that's forgiven, and they look at a pattern, 2, 3, 4, when it comes to security violations. But in this particular case, they said 1 and you're out. And it was a really stark contrast to what we were seeing with the Clinton case.
Do one more thing for me, because I want to get Judge McCasey's reaction to this thing, and then invite him to give his own angle on that matter. You raised this interesting point in your piece, The National Interest, about all of her aides on General Mills. These people may be guilty of violating the rules. Yeah, if they come into a new administration, they will come in with evidence of having violated the rules. Be rather suspect for getting security clearances themselves. In that case, what would happen?
Well, I think it's going to be fascinating to see how this plays out. If you look at the polls, I think it's looking more and more likely that she is going to be elected. And with that comes her people, if you will. Most of whom were intimately involved and implicit from what we know in setting up this server and maintaining it and participating in it. There's a very telling line in the adjudicated guidelines that says, in order to obtain a security clearance, it must be clearly consistent with the interests of national security. Clearly consistent. And it's a very high bar to me because essentially the burden of proof is on the applicant. Once the government raises a concern, there's no innocent until proven guilty. It's up to you to rebut those concerns. And we will potentially be in the very unique situation of having those at the top ostensibly running these agencies, her various top aides, and now having this very public precedent where she's going to be in the position of either letting them all off the hook, which she can do as president, or forcing them to go through the security bureaucracy for the very same conduct that she excused herself for. Never going to happen. So
it's Mel Brooks line. It's nice to be king.
This is very true, but I think the issue that the issue that it's going to raise is now you have this for the first time this very open precedent, and what are security adjudicators and administrative judges to do with that?
Michael, I think it's we're going to see. Don't think that the rules that apply to everybody, you apply to those by something other above.
Right.
Remember, just shut up, I explained.
What judges regularly do in, I'm sorry to say this, but what judges regularly do in situations like that, upon being told that somebody else got away with something that was far worse, is to say, that's interesting, but it's not my problem. It's yours, because all I have here is the words of statute or the regulation and your conduct, and I match the two of them up. What happened to somebody else is for another forum, certainly not for this one. And so as a matter of the way that courts proceed and the way I assume that the administrators proceed, this is going to cut me ice, which is a whole sad business in and of itself. I thought one way for me to approach this would be to go through my own history in looking at this problem, because I've deluded myself in public into thinking that there was no way that she couldn't be prosecuted. And I used to talk to Andy about this as the situation kind of ripened, and he sort of shrugged and shook his head. He said, "I don't think it's going to happen." I said, "I hope you're right, but I don't think it's going to happen." And I'd like to figure out if I could make Andy my professor and doctor for a moment, where it was that I went wrong. Start with statute. There are a number of statutes that potentially apply, one of which was the basis for prosecuting General Petraeus, in which he took classified information and put it off-site in a place where it didn't belong. And notwithstanding that the person he showed it to had top secret clearance, notwithstanding that there was it was demonstrable that there was no leakage of material because she was writing a book, didn't find its way into the book, didn't find its way anyplace else. His career ended, and he was prosecuted, albeit for a misdemeanor. He then take step up on anyone who places information either loses classified information or puts it in a place where it can be compromised, and does so negligently or with gross negligence. That's a felony. And at one point in his presentation, the FBI director, and I'm sort of skipping ahead for a minute now, the FBI director said, well, that's a constitutionally suspect standard because we don't prosecute anybody who's simply being negligent. And he seemed to have a sort of plausible point to consider that statute was put there purposely by Congress, knowing they knew what they were doing. And it's not that they were simply punishing negligent conduct with a felonious result. They were prosecuting a certain kind of negligent conduct, by people who should know what it was they were dealing with. And just to pick a kind of homey illustration, when you go to a restroom in a restaurant, there's always a sign there that says that the employees should wash their hands before returning to work. You can imagine civil liability being imposed on the restaurant if somebody doesn't wash his hands before he goes to work. On the other hand, if your surgeon doesn't wash his hands, you can imagine a criminal prosecution in that case. The same is true of people who handle classified information. At the first meeting that I attended, in which I was briefed on a classified subject when I became AG, as I do, took notes, figuring that I could use them on my computer to remember what I was being told. My chief of staff was a wonderful guy, saved me from many, many tough situations. At the end of the meeting, leaned over and wrote in big block capitals at the top, TS/SCI, meaning top secret analyzed information, meaning those are not your notes. Those are the government's notes, and you can read them in a secure, compartmentalized facility. But you can't just treat them as if you were taking notes in high school class. So I figured that it was clear that her conduct violated at least that statute. And then if you go up yet another level, the statute that criminalizes the destruction of information that is potentially relevant to an investigation. And it doesn't actually have to be a pending investigation. In fact, the part that says that there doesn't actually have to be a pending investigation at the time you destroy the material was put into the statute by Congress at the time that Hillary Clinton was Senator Clinton, and she voted in favor of that provision. So I thought, well, you lay her conduct alongside those statutory provisions, and it clearly fits. But then, how likely is it that this is going to be prosecuted? And I took a look at first line of judgment on that, which is the head of the FBI, Jim Comey, who for his entire career has cultivated a straight arrow image, including that episode in the hospital room that we all heard about, great drama, John Ashcroft. And turns out that was staged.
It had all the bearings of being staged.
Yeah, it was. I mean, he had apparently consulted the weekend before he gave that testimony with Senator Schumer and asked a question. So that he could then, when the question was asked, hang his head and say, oh, I knew that I would be called to account for this someday, and then proceeded to have the story pulled out. But in any event, he had cultivated this image carefully. He also had worked, after he left government, for a hedge fund up in Connecticut, where he had a bundle of money, so he was, but money wouldn't be a problem. He could go forward and bring a prosecution, or recommend a prosecution, or investigate without fear or favor. And if he was instructed to do something that he didn't want to do, he could resign publicly, and at a minimum, never pay for a drink again. Had it all figured out. And then you start to look at the dramatic persona. Hillary Clinton and her husband were vigorously disliked by the Obamas. This goes back to another movie. They didn't like one another. And then you had waiting in the wings Joe Biden, who would have made a far more acceptable, receptacle for the president's programs than Mrs. Clinton, who was first in line to cut the deal. It seemed to me that all the stars were aligning. It made sense, actually, from the president's standpoint, that she be charged, like anybody else, taken off the scene, and Joe Biden parachuted in. And I conveyed this story to anybody who would listen. And then listen to the broadcast that we all listened to when Jim Comey said that no prosecutor, no intelligent prosecutor, no reasonable prosecutor would ever bring such a case. I couldn't believe 20 years ago. So the message to get through to him? Where did he come up with that?
Well, I think we end up hitting on what actually is one of my sadly favorite themes, and that is that, and this heavily I think goes to your point about precedent as well, that we like to think of ourselves as governed by the rules of law, but ultimately we're a body politic, body legal, and in particular when you're talking about the executive branch, while we like to think that we're governed strictly by the rule of law, there's as much politics, and I don't necessarily mean improper politics. There's as much political choice that's involved throughout the executive branch, and that quite includes the law enforcement division of the Justice Department. There's much more political choice than we like to acknowledge. Let's just take it out of the realm of intelligence information, classified information for just a second. Right? The current administration, I want to make it clear here, I'm not making a political argument about whether this is good or bad, I'm just trying to make a point. And that is the current administration doesn't like a lot of aspects of the federal narcotics laws, including the mandatory minimums and other aspects of them. So what is it doing? On the one unreviewable side of what they're allowed to do, the charging side, they're charging cases in a way that the mandatory minimums don't kick in. And on the other side, that's unreviewable, the president is using the pardon power to commute sentences in a way that effectively eviscerates the mandatory minimum part of the term and essentially moves the narcotics laws into something that politically, and I mean that as a matter of policy choice, is more aligned to what he thinks the law should be than what the law actually is. Now, importantly, in terms of precedent, that won't mean a thing if a new administration comes in and decides to have different drug policies. No one will be able to say, you can't charge me with a mandatory minimum drug offense because, up until 3 weeks ago, President Obama was cutting all those people loose. That's unreviewable. And if you think about it, think about the manuals that we use in law enforcement, the U.S. Attorney's Manual in particular, but there are other practice manuals as well. Every single one of them, I think on the first page of it, says that this doesn't have any precedential value. You can't use this in court. You can't use this against us. If we decide to conduct ourselves in a way that's totally inconsistent with what's in the manual, that creates no legal rights for you. And as Judge Mukasey was saying, these cases come into court, and a lot of times people come in and say, I'm being treated unfairly. But there's a body of law, there's a narrow one on selective prosecution, and if you can get your case into that very narrow ambit of cases, you have a very, very thin, narrow chance of getting your indictment moving. But if you don't fit in there, most of this choice-making that's made by the executive branch is not governed by precedent. It's unreviewable political choice. So now, what happened in this particular case? I hear everything Judge Mukasey is saying, and I think that if you had an executive branch that was more committed to being governed by the rule of law, including ethical canons like if the appearance of impropriety would attach to the way you're going about a case, maybe you do something like appoint a special prosecutor or get it out or as insulated as you can from political choice, you do that. But in this instance, my view of it, for what it's worth, was that this prosecution was never going to happen because I didn't think that this Justice Department, which has been, I don't mean to get political, but it has been a very political Justice Department. I didn't think they would ever pull the trigger and indict Mrs. Clinton or her underlings. And that was my sense of it from the beginning, thinking that that was going to be more of a political decision than a legal one. And then in February, when it emerged that President Obama himself, and this was before we even knew that he was using an alias, right? President Obama himself had engaged in, I've seen it variously reported as 18 or 22 different emails or email chains with Secretary Clinton at the time. In February, that pretty much cinched it for me. I mean, I must say, I always held out hope that my old friend Jim Comey would make a bulletproof case and put it in the Attorney General's lap and make it very difficult for her not to indict. But once it was clear that the president had exchanged these emails, that in effect meant that even though it was in much smaller scope, he had committed in principle the same misconduct that she committed. And that was clear not only from the fact of the reporting, but the fact that in order to avoid what would have been an effective confession that he had engaged in the same conduct, they invoked executive privilege. They didn't want to call it executive privilege, that sounds too much like Nixon, but they effectively invoked executive privilege in order to avoid having to post hoc classify these emails. And therefore they are, sort of buried, and who knows if or when we'll ever be able to see them again. But it seemed to me that once it was clear that President Obama was personally involved in this and had engaged in the same conduct with Mrs. Clinton, such that if you were to indict Mrs. Clinton, those emails would either be admissible evidence in prosecution against her, or used by her defense to say, how come I'm being charged and he isn't? There was no way on God's green earth that this case was ever going to be indicted. The political reality was that it wasn't going to be indicted. And, one last point. Justice Scalia said this in, was it Morrison v. Olson, I think, in the 80s. And it was true then, which is why he said it, and it's as true today as it ever was. And that is that all of the authority in the Constitution that is vested in the executive branch is vested in one person, the president. And everybody in the executive branch may think of themselves day to day as carrying out their responsibilities under the rule of law and the regulations that apply. But every day you work in the executive branch, you are exercising the president's power. And if the president wants something done, your choices are either to carry out the president's will or to resign. And to my mind, if President Obama had any involvement with this, he was not going to allow, whether he had to say it directly or make it clear in other ways, he was not going to allow prosecution in this case. And if that's the president's will, you either carry it out or you resign. And I think what happened here is people carried it out.
But just go back for just a moment. What you're presupposing here. Why, just as thought experiment, why couldn't he simply invoke the same understanding you invoked a moment ago and say, well, I'm president. No presidential value attaches to what I decide. I'm president, she is not. So that it's looking behind this again. You think there is some bearing on the situation, is there some embarrassment if they're using different rules? Yeah, he's going to be, right? So the logic of the president, the question of, would I be indicted by the same rules that would be used to indict her? That I would come under the same accusation? That's in play.
Yeah, but the wonderful thing about...
Whether it leads to a prosecution or not.
Yeah,
but what seems to be in play here is the awareness of that logic.
Yeah, but the thing about unreviewable discretion is that you are not obliged to be logical. Mm-hmm. You can do what you think you can get away with.
Why would it be a problem? Why would it be a problem for him unless he saw there was a commitment?
Because there could be political fallout from it.
Political fallout.
We're not suspending. We may be suspending rules of law and precedent, but we're not suspending ordinary politics. right? I mean, if he does something that's over the top, nakedly political, and people don't like it, there'll be fallout from it. And frankly, you know, look, if Mrs. Clinton wasn't running against Donald Trump, who has his own baggage, right? I suspect she'd be way behind in the election if she was just running against any conventional Republican, and it would be precisely because of this.
Judge,
yeah, there was available to the president or to the doctrine, and I don't know whether it would apply to his communications with her. A rule that says, in essence, that the executive can disobey a rule that is not really intended to protect any particular person, so long as they're doing it for important governmental reasons. Best illustration of that is the fire truck that violates the speeding rules on the way to the fire. Now, whether he could make that case for his communications with her and not for her communications with him, I don't know.
And the alias.
Right, and well, the alias is.
I mean, the fire truck, when it goes down the street, it looks like a fire truck.
Yeah, they don't. there are no plainclothes fire trucks.
But look at it from this angle. I mean, I can't get quite away from that question of the principal case here. Sean, you're aware that people who are in positions to start to apply the rules and are faced with the task of bringing down the hammer on the law, people who have done things far less grave than she's done, and feel certain reservations about doing that. And in fact, you said that in dealing with your own cases, you would count yourself guilty of a certain kind of malpractice if you did invoke the Hillary precedent.
I think therein lies the key difference between the universe that I operate in and the traditional criminal prosecution. We litigate character, really, at the end of the day. These are predictive determinations about somebody's integrity and reliability and fitness to access classified information. So in doing so, it's only natural, I think, that anybody who is making those calls would have a bit of a gut check in a situation like this, where they would say, I just sent out the door a good man, somebody who's, you know, a sole breadwinner with children at home, and they've had a 20-year career serving this country, but they made one too many mistakes, and now they're gone, and now they've lost their career. And is that the fair, is that the ethical thing to do, and what are the interests that are being served by doing that when we're allowing those at the top to get off the hook for the very same or worse conduct? And on that point as well, you know, I think it's important to note here that the ability to grant or deny a security clearance lies solely with the executive. The Supreme Court has made that very clear. There's a fairly little known 1988 case in which a gentleman challenged the ability of the government to deny him a security clearance, and ultimately the Supreme Court said no. If the executive doesn't deem you fit for a clearance, then there's no further inquiry. These decisions are not subject to judicial review. They're entirely administrative in nature. Now, fortunately, most federal agencies have carried that out with reasonable fairness, and there are due process considerations in place for applicants. But certainly, I think this issue of the double standard is more applicable and more salient in a case where you're litigating character than in a case where you're narrowly applying a statute.
Let me check. Well, let me have one more. I can come back on this, and then I want to maybe throw it open to some questions from our friends gathered here. As I listen to this kind of, these are administrative decisions, and what goes on in one room may not take place in another, and the judge, this is what this judge may say. It also reminds me of what Max Weber called a form of county justice. You know, the county simply issues the decision. You know, the famous case of the county listening to a complaint of a husband and wife, and he tells, wife comes in and tells her she's right. The husband comes in and she says, you're right. And the wife of the county standing by comes in, well, you told her both that they're right. He says, you're right. And the whole Bible is what issues is only decision. No reasons, nothing we can test. And yet, if we're faced with this question that Bill and I raised years ago about did you think suborning of perjury was a fit ground to vote the impeachment of the president? Why is it not apt to raise the same question now? And if we can't raise that kind of question, what does that say about the current state of the political class of this country?
Well, here we get into a whole other area where the question becomes, is this really a law enforcement or judicial problem? I mean, I wrote a book about this a couple of years ago, precisely because impeachable offenses are ones that go to abuse of authority. They don't have to be indictable offenses, right? You should be able to remove somebody for any kind of profound abuse of power or incompetence, even if you wouldn't be able to convict them in trial. And to my mind, if the system was working properly, we wouldn't even be talking about whether Mrs. Clinton should have been indicted or not, because as far as the public is concerned, the public interest is concerned, it's far more important that somebody who conducts themselves as a rogue in power have the power taken away than the question whether they ever get indicted and convicted and sent to jail. And so, to me, that's a very secondary.
Yeah,
notably in impeachment cases, if you are charged and convicted, you may not then hold any office under the United States in the future.
But just one last point. I can't think that Judge, you may remember, Michael, the district court judge, he had that case of Dobbs Ferry of Bishop Lynch and other Brzezinski sitting outside the abortion clinic. He managed to spring them, saying, invoking the question of the future of society class. Okay, but what if we think it's utterly implausible that a judge dealing with these cases would simply invoke the Hillary Clinton precedent and said, given what's done here, I was saying we could enforce this condition in regard to this particular litigation.
Only within the limits of the discretion that the judge has, and those don't include, for example, dismissing an indictment. That would be and could be appealed by the government, and reversed.
I was just going to say there's an interesting area where you see this interplay, and we saw it in our case to a limited extent. There's been a lot of subsequent terrorism cases where you see it more, is in applying the Classified Information Procedures Act, because that's an interesting tension between law and executive discretion, in the sense that the classified information belongs to the executive branch. But the four corners of the judicial proceeding, the court is supreme, the judiciary is supreme. So it's one of these rare things where the Attorney General is actually empowered to order the district court not to disclose the classified information, even if it is essential to the defense of the person who's been charged. And the judge must follow that directive, but because the court is supreme in the judicial proceeding, the judge can then start dismissing the indictment or dismissing counts, etc. Because if a person can't get a fair trial, then that's what the judge has to do. And I think the point, Hadley, is, as far as what you were talking about precedent, the line is, once you go from something that's a unilateral executive branch show, which is, does somebody get charged or not, and it gets into court, where it really is the rule of law and it's congressional statutes rather than executive guidelines, then you're in a completely different ballgame as far as precedent is concerned.
Okay,
I was just going to, I think Andy raised a really interesting point with SEBA, the Classified Information Procedures Act. There are, if you read the FBI report, a stunningly high number of what the government would term security violations in the way in which Mrs. Clinton and her team handled their server. And not only their server, but just classified information in general. they took a very lackadaisical approach to protecting the information. And some examples of that were, there was an incident, at least one, where one of her staffers was alleged to have stripped the markings off of a classified document. That is a gross violation because anybody who subsequently comes into contact with that doesn't know that it's classified. Another example is there were a number of instances where the FBI found that Mrs. Clinton and her team had kept unclassified computers or cell phones, different electronic devices, in what's called a SCIF, Sensitive Compartmentalized Information Facility. And if you've ever worked with classified information, it's basically a room that's soundproofed and bug-proofed and a lot of technical specifications. It's the only place you can go to review a certain level of classified information, anything above top secret. And the idea is that anything that's brought in from the outside that's unclean, any type of technological devices, create a risk that eavesdropping could occur. Specifically with cell phones, we know for at least a decade now that foreign intelligence agencies have the technical capability to turn on remotely a cell phone of a target and use it as a listening device. They can actually remotely access the microphone inside the cell phone. So if you bring that into a SCIF where classified information is being discussed, now there's the potential for that to be exposed. So there were a number of really egregious violations, and each one of those, for the common man, would be a reason to revoke a security clearance.
And just to show how top of mind this should have been to the Secretary, the Situation Room at the White House has outside it an array of little boxes where everyone who enters is required to put his or her cell phone. You don't go into the Situation Room carrying any kind of electronic device. You put it in a little compartment and you collect it when you go out. She's obviously been in there. We saw the photograph of her going like that during the Bin Laden operation. So we know she's been there at least once. I guess she's been there more often.
So we take it that the Hillary Clinton would not be wanting in zeal to keep from public gaze any information she wishes to keep from public gaze. And if those have to be secrets of government that she'd like to keep from public gaze, we could count her being very diligent in trying to enforcing those rules, right? So the question is, but why do you reconcile that with anything else you're doing that is that old problem I was just mentioning before? Read Lardner's famous line when he was lost in New York with his 5-year-old, and the 5-year-old says, "Daddy, I think we're lost." And he says, "Shut up, I explained." Shut up, I explained. That may be the answer there. Okay, I think why don't we have a lot of final comment or any other solutions about questions from friends in the audience? I get all the way back, and I get you over here. Okay. How do we do this, Gary? We have a mic that we can share.
I have a big mouth, so I mean I can.
I can hear you. We can hear you.
Okay. So, when Director Comey announced that Hillary Clinton would not be charged, he mentioned that there was no criminal intent, no guilty mind, so to speak. But the statute on point specifically has a standard where it says that the person should not be grossly negligent when handling such information. And then he subsequently said, well, she was, however, extremely careless. In my humble opinion, those are pretty synonymous. But I guess my question is, what kind of precedent does that set where you have people reading a mens rea standard into a regulation or a statute where the statute specifically says that the standard is lower than that for criminal culpability?
The Supreme Court decided a RICO case in the early 90s, and I'm having a
Scheidler?
Yeah, Scheidler. In which it said that courts are supposed to apply the statute as it's written, and government guidelines are not supposed to make a difference. Convenient little parts of the legislative history that you mine out of it in order to try to attack the prosecution aren't supposed to make a difference. They're supposed to apply the statute as it's written. For what it's worth, I think there were a couple of things wrong with Director Comey's analysis on that, more than a couple, but just speaking of two of them, number one, I think there was plenty of evidence that she actually fit in the willful subsection, not just the gross negligence subsection. And that would have been a fun case for a prosecutor to try, frankly. And I think it's important to point out, at least looking at this as a trial prosecutor, most of the cases where you can prove that the person has taken all of the actions that are necessary to commit a violation, but claims, usually implausibly, that they didn't have the intent to violate the law, those cases go to trial. I mean, you indict them and you let the jury decide whether the person had the intent or not. And most people who raise those defenses get convicted. The second thing was Director Comey, and I think Judge Mukasey talked about this earlier, made this argument that there was a potential constitutional infirmity in charging somebody criminally with negligence. And I think, as a matter of law, that just doesn't withstand scrutiny, because virtually every state in the United States prosecutes, for example, negligent homicide, right? But the other thing about it is, this particular statute, he kind of described it as if it were an outlier, and suggested that if we allow this to be criminal, then anybody can become vulnerable to criminal prosecution for negligence, which is the civil standard. And in fact, when you look at the Espionage Act, Section 793 of the Criminal Code, at least this is the pertinent part of it, this is not an outlier. This is a carefully calibrated statute that contains at the very top traditional espionage offenses where you're actually trying to do harm to the United States. And then there's a middle level of willfulness offenses. And then there's a bottom level of gross negligence offenses, not just negligence. But think about who they apply to. This is not gross negligence across the board at everybody, right? This is a narrow class of potential offenders who have all been schooled in how you handle and what's expected of you in handling classified information, who are kind of a special breed because they know what they're supposed to do, and they know what the rules are, and they basically have to sign off on knowing what the rules are before they get access to the classified information. So I just didn't think his legal analysis held up.
One thing I think on that point, too, that no one has really asked or pushed is why the server was set up in the first place. Her initial argument was that it was for convenience, and she only wanted to carry one device, but we now know she didn't carry just one device. So the logical question then becomes, was it done to shield your communications from political repercussion?
Clinton Foundation.
Right. Or was it done for some other nefarious purpose? Either way, it seems to me like you can read in intent.
Just one question on that. The problem would be that she wanted to harm the United States, not by having the server hacked. She would prefer it not be hacked. But she did want to protect her communications and thereby avoid the transparency laws in the United States, and that is harm to the United States.
Yeah, the Federal Records Act. I mean, that's the not so sexy aspect of this that nobody really talks about. That's another underlying issue here, is that she's evading another federal statute that's designed to preserve these records for a variety of different purposes.
I think also this becomes important in a lot of cases. You always have to sort out motive from intent. I mean, they sort of blend to normal people, but when we're doing these cases, we have to sort out what they mean. And even if your motivation is not to violate the classified information laws, if you take actions, the natural foreseeable consequence of which are things like compromising classified information, that satisfies intent. It doesn't have to be your motive. It doesn't have to be the primary thing you were trying to accomplish. It just has to be something that was foreseeable and you knew it, you did it anyway.
That was Bill Atkinson, by the way. I should have people identify themselves. This gentleman over here was trying to get in earlier. We have a mic.
Yes, sir. My name is Comey, but I'm with the Pakistani Spectator. And my question is, what is the practical significance of Ms. Clinton's mishandling classified information? How does it affect average person? It's the same kind of scenario when Bill Clinton once said, "It's economy stupid. People don't care about other things." And it's very obvious that, it's very likely that she is going to win the White House. So since it didn't affect average person on the street, average person doesn't care. So they think, oh, okay, it's just for some individual like yourself doing intellectual masturbation. She didn't hurt any institution, she didn't hurt any individual. It was just negligence, and a lot of people do negligence, so it's not a big deal. So again, I mean, what is the practical significance in political environment now, what she did? I mean, what FBI director did, Comey did, and what Obama himself did. Basically, he too was involved, according to what she wrote here. Thanks.
Well, I will speak from just my personal experience dealing with the national security bureaucracy and the intelligence community, and I can tell you that it is a group of people who very much value the rules and following them. And it's a way of life for many of these people, because at the end of the day, being careless with classified information can put somebody's life in jeopardy. Truly, the nature of the information that was put in jeopardy in this particular case was at what's called the SAP level. And that is typically reserved for information that would, if it got out, expose the identity of a foreign intelligence operative or some other classified source and method that would put our people in grave danger overseas. So when you have a national security apparatus that has lost respect for those at the top, I think it's very hard to govern effectively and to run a bureaucracy. So it remains to be seen whether she can turn this around. But if she does in fact win, I don't think there's any question that many of those who were with her at the State Department and involved with this will be placed into high-profile positions running various agencies. And as I said earlier, the question really becomes, now what do you do when we have this very public precedent out there of people sort of being able to escape consequences?
How do you think that demoralization will be manifested? Is it be people dispirited or expressed in some other way?
Well, I've had a number of off-the-record conversations just with my contacts inside the intelligence community, and I think the general consensus that I've heard is, what is the purpose of enforcing these rules on the little people if the big fish get to walk? And it is a nuanced argument, because from a true legal perspective, as Judge McCasey pointed out earlier, two wrongs don't make a right. I mean, it's a very old maxim. But from a philosophical standpoint, when we're judging character and when we're judging fitness to access the nation's most closely guarded secrets, I think you do have to ask yourself if that's something that will come into play.
I think it also will tend to accelerate the phenomenon that we've seen several times with people who lose policy arguments within the bureaucracy feel free to disclose even classified information so as to get their policy point of view heard publicly, and believe that they are speaking in the name of a higher good in doing so. People have done that in the past and more than they do in the future.
They also confirm this says that moral logic of precedent makes its way through to ordinary folk, even while we may give other legal accounts of why the executive has a kind of discretion that may not lend itself to presidential value.
Okay, I can just
Go. About just short.
look it up.
And I should keep a file.
My name is Mark Venezia. So I have two relatively simple factual questions. So the first one is just yes or no. Were all of the deleted files, I guess 30,000 deleted files, recovered?
No.
No. No.
A tenth of them? We don't know.
I think he said thousands, but thousands were lost as well. So.
Okay, first question. Second question is, what was the source back in February that the president's emails were on the server? What was that source? So these weren't deleted, I guess. Or they were discovered in some other manner.
You mean
The source of the reporting?
Yeah, I think it eked out of the FOIA litigation, but I'm not 100% positive about it.
But does that mean back in February you were certain? Forget it.
No.
But what else do we have now? Some correspondence that was in the wiki disclosures.
I felt strongly that, and that's why I wrote about this in February, that the president had such a profound conflict of interest in this that it's difficult to see how charges would be filed. But I can't sit here and say I planted my feet and said never ever happened. And a lot of that may be because I know Jim Comey for almost 30 years, and I hoped, as I said before, that he would put a very strong case on the Attorney General's desk and make it politically very, very difficult for them not to charge her. But you know, I always thought that the president's conflict was a big problem.
So the wiki disclosures are irrelevant.
Well, they're not irrelevant because we now know that as soon as the House committee issued the subpoena, which is right after the New York Times broke the case, the Times breaks the fact that she has this server around March 2nd of 2015. March 4th, the Benghazi committee issues a subpoena. That very day, we know from the WikiLeaks, the Podesta hacks, right, that two things are going on. The Clinton campaign team is scrambling with how are we going to deal with the Benghazi subpoena. And we know that, for example, Cheryl Mills and Mook, the campaign manager, have an exchange where he says, just to be clear, the subpoena is only for the Benghazi emails, right? It's not all the emails. And Mills confirmed to him that he's correct. That exchange is about 3 hours or so between the time the question gets asked and the answer gets given. In the midst of that, Podesta, who was at that point transitioning from being the president's top advisor in the White House to the chairman of the Clinton campaign, emails Cheryl Mills and basically says, what are we going to do about the Obama-Clinton emails? I guess we should invoke executive privilege. That's not a quote, but that's basically a record of what the email says. So I think you have to ask, at the very least, does the Benghazi, were they at a point in time that they were so concerned about Benghazi emails, and then suddenly somebody thinks, gee, what about the Clinton-Obama emails? Is there a Benghazi time? It doesn't mean it necessarily is, but there could be.
Okay, we have two more questions to end. We have Bob Destro and Dan Oliver. This was Mark Venezia, by the way, from this question. Bob Destro.
I have a question about the process here. I mean, when Andy was talking earlier about how the president more or less is the person who decides, is this going to go or is it not going to go? But under the Classified Information Procedures Act, the actual prosecutor would have been John Carlin, the Assistant Attorney General for National Security. And it seems to me that under the Act, you only have, he's the one who made the immunity decisions, Loretta Lynch did, Sally Yates did, or the president did. It seems to me that somebody, the question, the silence of the press on the question, who's the prosecutor? Because Comey said in his testimony that I didn't make those decisions. And what I've been amazed at is, well, who did? You know, and that's what I'd like to ask the three of you. Like, how does this actually work in practice? Because it could be that a reasonable prosecutor wouldn't bring this case because you'd have to kill the jury you showed it to. You know, because it's too highly classified. And if you do that, then you have to file a report with Congress, which would be as bad as an indictment.
Well, let me say two things. Number one, CIPA probably doesn't, classified information procedures only become relevant once you charge the case and it gets into court, right? Because then what that's all about is what evidence is going to be admissible at trial. Before you get to that point, you're in the land of executive discretion. I don't think that there's necessarily the kind of a strict hierarchy or chain of command like you're talking about, but it is very important that only the Justice Department can grant immunity. The FBI can't do that. And most of these decisions that affect the eventual ability to charge someone or not, the Justice Department has to be cut in on. And I think, Judge, isn't it true that if it's a classified information case, they have to be, the Justice Department's national security people have to be involved in it, just in terms of being able to scrub documents, right?
And as the National Security Division would have to pass on that. But as far as authority to grant immunity, that I think is the assistant AG level. So it requires approval at that level. And so you're talking about either John Carlin or the head of the criminal division, or Sally Yates, who's deputy, or the AG.
Bob Dester has a fine piece of this one, which I hope will be seen before long, but John Carlin has quietly left the government again, right?
Yeah. He just got invited to his going away party. He just got invited to his going away party.
Okay. Dan Oliver will have the last question. Okay.
What is the statute of limitations? Does it exceed 4 years and 3 months?
I think it is the ordinary 5-year statute of limitations, but importantly, the next administration, even if it were of a mind to prosecute this, would be stuck with the immunities that have already been granted. So to the extent that people have given up information because they've been immunized, that's not something that gets revisited. That's nothing you can do about that.
Just to go back for a second to this gentleman's question over here, I think you raised an interesting point about the role of the lawyers in all this. And since many of us in this room are lawyers, I think it's worth just noting how extraordinary the involvement of Mrs. Clinton's attorneys were in this whole scheme. I've never heard of or seen a situation, and I'm sure it's the same with Judge McCasey and Andy, where essentially conspirators in a situation are then deemed to be attorneys and allowed in on interviews. And so I think, you know, the lesson to me is, as a somewhat sarcastic takeaway, I guess, is if you're planning on committing a conspiracy, make sure one of your co-conspirators is a lawyer.
Preferably a lawyer who's also employed by the government. I believe Cheryl Mills claimed that she was the Secretary's lawyer at a time when Cheryl Mills, was employed by the State Department.
Well, I know in the Southern District of New York, it used to be a sort of a common joke in the hallways, especially as you were coming back from court proceedings, to say, I hate these people and their lawyers. And their clients. I'm sorry, I screwed up the joke. But, I've never before seen it quite melded the way it was in this case, where you actually had somebody who was the subject of an investigation, who got immunity from prosecution for turning over physical evidence that had classified information on it that was not authorized to be on the computer, that was then allowed to be a lawyer in the case representing the co-conspirator who, if there had been an indictment, she would have been the main witness against. That was a new one on me.
This sounds like a Mel Brooks combo. Listen, you've all been very clear to care about the time. I wonder if you'd indulge me to finish in this way. I'd like to invite our guests, our friends who come to this one, so any last words. And then, if you would indulge us, I'd ask Mike Maybeck to do 90 seconds, which is to tell the friends gathered here just what plans may be afoot. But first, Mike, let me just return to our guests, our friends. Any last words?
It's an ominous invitation. Any last words?
His brother was worse. Yes, I know.
No,
Any sage words to close?
I think the the damage that was done to the concept of sort of one aspect of the rule of law, i.e. that the same rules apply to everybody. The damage that was done is something we're going to be dealing with for decades.
Once again, the condition of the political class. Sean?
Well, I guess first off, it's been a privilege to be sharing the stage with you folks. I feel a little bit out of place up here, to be sandwiched between legal titans, but it's really been, I think, a fascinating experience watching this unfold. And the real question, I think, does remain, what happens after she gets elected? So I guess look for her people and where they wind up in a subsequent administration, and that'll tell us a lot about what ultimately became of their security worthiness.
As some great jurisprudential mind once said, meet the new boss, same as the old boss.
Well, after this rather grim, I'll use that line I used once that Nino regarded as his favorite exit line. It was a reworking of a line by Woody Allen where he said, there is no question, there is out there a moral world somewhere. The only question is, how far is it from Midtown? How late does it stay open? Would you give 90 seconds to our dear Mike Mayback to make a pitch?
All right, thanks, and thanks for coming tonight, ladies and gentlemen. We value your time. We know you have many opportunities to do things, and we're happy to have you with us. Cicero that unless you study history, you're always a child. And so we study American history. We study our Constitution, and therefore we have to study the principles that inform the people that wrote our Constitution. That includes natural rights. And so that's what we do at the James Wilson Institute. We engender the study of natural rights. We do that through public forums, through senior seminars with appellate attorneys and judges and scholars. And every summer, we bring for 1 week to Washington 15 newly minted attorneys on their way to being clerks in appellate courts, Supreme Courts of the state and the federal level, etc. And they spend a week with Hadley and gentlemen and ladies that are scholars of these questions. And so we'd like you to help us sustain our work. We have a membership card if you'd like to join. We're starting our membership program this evening, so you can be charter members. And we're going to seek to have 15 people become sponsors or patrons of each of those 15 fellows in the summer. And if we have those 15, we can financially sustain that program on its own. So with that, we're going to thank you for coming. We have a reception. You can have drinks and continue this conversation. We value your attendance and your engagement with the James Wilson.
Yes, yeah.
Thank you.
To thank everybody for carving out.